Hold the case.
Resume to the virtually Thursday, the 23rd day of March 2022 for the Lordship of Honorable Justice. Sanusi Kabuki Kanyip. Suit number NICM CA 63-2022. Between 1, the Above Investment Limited. 2, High Chief Basi Utombasi. And 1, FIFA Seal Nigeria Limited. 2, Mr. D. Taga. 3, Mr. Sanja Manga. 4, Mr. Tipson Isora. My Lord, parties are all absent, my Lord.
Appearance. Appearance. Yes, Lanesik.
With utmost respect to your lordship,
Yes.
I appear for the defendants. Lai Babatunde SAM, my lord, for the defendants.
Yes.
My learned friends, David Oweye. And Tolani Lai Babatunde. The Lai Babatunde with an knife from my lord.
Okay, with David Owaye and Tolani.
Yes, my lord. Lai Babatunde.
Okay.
The Lai Babatunde with an knife from my lord.
Yes, yes.
For the defendants applicants.
Yes. It appears the claimants and their counsel are not in court, and they are not online as well. But this matter is for ruling.
It's for ruling,
the
sir.
ruling of the court is ready.
As the court pleases.
This is my ruling. The claimant commenced this action by the general form of complaint dated the 16th day of December 2022 and filed on the same date, wherein they claim against the defendant as follows: A declaration that the defendant's failure to supply the construction materials within time stipulated in the contract agreement of 14th day of September 2020 amount to breach of contract. Hence, the claimant are entitled to damages in law against the defendant. B, a declaration that the defendant refusal to pay the claimants the contract sum as to the level of work done and refusing to demobilize them of site since after the inception of the contract in 2020, thereby causing the claimant to incur huge financial costs to maintain her personnel and equipment amount to breach of contract. Hence, the claimants are entitled to damages in law against the defendant. C, an order of this honorable court that the claimants are entitled to special damages of $5 million United States American dollars as agreed and contained in the contract agreement in favor of the claimant. D, an order of this court directing the defendant to pay the claimants a total sum of $504,225,000 naira, being cost incurred for maintaining personnel and equipment on site for the first 360 days, 11 months, which is 11 months, at 1,200,000 naira per day. E, an order of general damages in the sum of 500 million naira only for the defendant as compensation for breach, economic hardship, and physical trauma caused to the claimants and her laborers labored staff maintained on site without payment. F, an order of 5 million naira cost of litigation. Upon being served with the originating summons commencing this suit, the defendant on the 23rd day of December 2022 entered conditional appearance and on 16th day of January 2023 filed this motion on notice dated 16th day of January 2023, praying for an order of this court striking out or dismissing this suit for want of jurisdiction and or for constituting an abuse of court process. The application was brought pursuant to Section 6, Subsection 6, Section 36, Subsection 1, and Section 254 of the Constitution of the Federal Republic of Nigeria, 1999, as amended. Order 17, Rule 1, Sub-Rule 1 to 6 of the National Industrial Code Civil Procedure Rules 2017, and under the inherent jurisdiction of the court. The grounds for this application were given as follows. I'm going to skip reading the grounds. The application is supported by an 18 paragraphs affidavit sworn to by one Rajesh Sharaf, an employee of Skippers Nigeria Limited, that is space dependent. A further and better affidavit of 15 paragraphs was also filed in response to the counter affidavit of the claimants. Lai Babatunde SAN counsel for the defendants applicants, while arguing in support of the application, informed the court that he is relying on the deposition contained in the affidavit in support and the further and better affidavit. Counsel also adopted the written addresses filed along with the motion on notice and the further and better affidavit as his argument in this application. In the written address, a single issue was formulated for determination, to which, whether having regard to the circumstances of this application, the interest of justice will be better served by the grant of this application. In arguing the sole issue, the learned senior counsel submitted that by inherent powers vested in this honorable court and by virtue of the relevant provisions of the Constitution of Nigeria 1999 as amended, other enabling status, relevant rules, and decided cases, this honorable court is empowered to strike out and dismiss any action in which it lacks jurisdiction and or it deems fit as constituting an abuse of process. Counsel further submitted that the issue of jurisdiction is vital and important. It can be raised at any stage of proceedings or even orally before the honorable court. It can also be raised suo motu by the court or even in appeal. In support of this contention, reliance was placed on the case of Projessica Enterprises Limited versus Leventis Technical Company Limited and host of other cases cited therein. The issue of jurisdiction can also be raised for the first time at the Supreme Court. The objection it is submitted is therefore properly raised by the defendant applicant herein. Reliance was also placed on the case of Abraham Adesanya versus the President of the Federal Republic of Nigeria and another. The learned six further submitted that by affidavit in support of the application, the applicants have stated uncontestable facts and have provided documentary evidence in Exhibit A, B, and C to show that not only this court is bereft of jurisdiction, but that this matter is premature and not one in which this court's jurisdiction should be invoked at this stage, as it is patently premature having regard to the agreement of the parties. Reference was also made to the meaning of jurisdiction, wherein the Supreme Court, in the case of Obi versus Anek and others, stated that jurisdiction is a legal power or authority that enables a judge to enter into adjudication in a matter before him. In the same case, the court had held as follows. Let me quickly say here that once a court lacks jurisdiction to entertain suit, the only steps it could take in the matter is to make an order striking out the suit. Any other pronouncement made by the court after declaring that it lacked jurisdiction to entertain a suit is null and void and of no effect. It is the applicant's contention that in the instance circumstances, this honorable court lacks jurisdiction to entertain this suit as it is currently constituted, or that such jurisdiction should not be invoked at this stage of the dispute between the parties, as the contract between the parties categorically states the procedure for resolution of dispute or conflict. It is also the submission of learned senior counsel that it is settled law that non-juristic entity can neither sue or be sued. In support of this submission, reliance was placed on the case of Powemi versus MBA number 2. It is further submitted that action commenced against non-juristic entities, if held to be a non-juristic entity, is a nullity and ought to be struck out. To support this contention, reliance was placed on the case of Anegan versus Cementation Company Limited. Counsel at the learned senior counsel at the court to hold that the first defendant is not a juristic person known to law in Nigeria. It is also submitted that despite the dispute leading up to the filing of this suit is alleged breach of contract, this matter is neither ensued from a labor employment nor trade dispute, but is expressly a matter that bordered on alleged breach of contract. It is the humble submission of the learned that, going by the jurisdiction of this court, as clearly spelled out in section 254 of the Constitution, this court is bereft of jurisdiction to entertain this matter. Counsel at the court to decline the claimant's unwholesome invitation and dismiss this suit for being vexatious, there an abuse of process of court. It is also argued that the claimant's respondent are in breach of the said contract by filing this suit, while it has alleged and plead a service of notice of arbitration. Yet the claimant in another breath also seek to bother this court in this suit, contrary to having recourse to the mode of dispute resolution already stated in the contract. This instant suit filed by the claimant is premature and constitutes a breach of the clear agreement between the parties. In support of this submission, reliance was placed on the case of Mekwe versus Imokude, where the apex court held, where the intention of the parties to a contract are clearly expressed in document, the court cannot go outside the document in search of other documents not forming part of the intention of the parties. It is the submission of the learned that it is apparent, with respect to the issue raised above, that the claimant has resorted to using court process to harass and intimidate the defendant applicant in submitting to its demand, while the breach of the contract and not in breach of the contract and not fulfilling its obligation to the defendant. It is settled law that parties are bound by the terms and provisions of their contract, and that the court will not rewrite the agreement of parties, nor nudge them to depart therefrom. Counsel relied on the case of Lamy versus DPAM Limited, wherein the apex court held that it is always not business of the court to make contract for the parties before it, or to rewrite one already made by them. Once the condition precedent to formation of contract are fulfilled, the parties thereto are bound by it. See the case of Oyenuga versus Provisional Council of University of Ife, and the court will not necessarily interfere with the terms of contract of the parties, as same may lead to infringement of fundamental right of fair hearing of the parties. In the case, in reliance on this submission, reliance was placed on the case of Lamy versus DPM Sufra. It is also submitted that courts are usually confined to the four walls of agreement entered into by the parties. In effect, the law of the parties, the laws is that parties voluntarily entered into, and the court cannot rewrite it for the parties. It is submitted that the arbitration clause in the contract between the parties and the claimant has, as admitted by the claimant, is for the claimant to initiate arbitration proceeding and not to belabor the court with litigation. It is also submitted that the claimant respondent is very well aware that he ought not activate the jurisdiction of this honorable court without meeting the preconditions stipulated in the contract, that is arbitration. The case of Madukolo versus Nkendile was cited in support of this proposition. It is submitted that arbitral agreement between the parties to which the claimant voluntarily subscribed to constitute a feature in this case that prevent this honorable court from exercising its jurisdiction in the circumstances. It is the learned as the court to so hold. In the light of the circumstances of this matter before this honorable court, the applicant therefore hold the firm view that the competence of the honorable court to entertain this suit is lacking, and ask the court to take this matter out of its docket. The applicant therefore prays this court to dismiss this suit being an abuse of process of court, as it is intended to intimidate and harass the defendant's applicant and to waste the precious time of the court. To support this submission, the case of Ukachukwu versus PDP and 4 others was relied upon. The honorable court is urged in the interest of justice to grant the prayers contained in the application, as same will save the court times that could have been expended in dealing with other matters of the court on the course list. In concluding his submissions, the learned submitted that in having regard to the affidavit evidence and the submission made, this court should grant the prayers as contained in the application. In opposition to the application, the claimants respondent filed a 15 paragraphs counter affidavit, a written address, and a written address. Ayo Edem Duke Esquire counsel for the claimants respondents in arguing in opposition to the claimant's motion, to the defendant's motion on notice, adopted rely on the deposition contained in the counter affidavit and adopted the written address as his argument. In the written address, counsel adopted the issue formulated by the defendants as the only issue calling for resolution to it, whether having regard to the circumstances of this application, interest of justice will be better served by grant of this application. In arguing the sole issue, counsel submitted that the defendant's sole issue for determination is answered in the negative, i.e., that is to say, interest of justice will not be served if this application is granted. It is the submission of counsel that on the issue of jurisdiction raised by the defendant in respect of the claimant suit, that the claimant suit and the defendant and the claimant suit and the subject matter thereto have a statutory label as well as falling within the jurisdiction of this court. To support this contention, counsel relied on the case of Goldmark Nigeria Limited versus Ibapon Company Limited. It is also submitted that the activities of the claimants and the dependents and the employee of the claimants and its denied wages are all within the contemplation of labor practices. It is also submitted that there is no feature in the case that can prevent the court from assuming jurisdiction. In support of this submission, reliance was placed on the case of Abbas versus Terra. On abuse of process, the defendants have also, on the issue of abuse of process raised by the defendant, the claimant submitted that there is no element in the claimant's case that indicate abusing a process of court, as the case before the court was dutifully instituted upon the fulfillment and lawful termination of contract by the first defendant. In support of this submission, reference was made to section 254C1 of the Constitution as amended. Counsel also relied on the case of Savannah Bank of Nigeria versus Jaten Kentu. where it was held that the duty of court is to decide rights of parties and not to punish them for errors, if any. Counsel asked the court to assume jurisdiction and entertain the matter as filed by the claimant. On the submissions of the defendant that the first defendant was wrongly sued and is a non-juristic person, the claimant submitted that the defendant at all times knew the first defendant with that name, and is evidence on Exhibit BA. There was never a time the certificate of incorporation of the first defendant was made public to the claimant, and that there has never been a protest from the second to fourth defendant as to the propriety of the name during the contractual dealings. Counsel submitted, assuming but not conceding that this argument has anchored in law. This court is still vested with an inherent power to allow for an amendment to reflect whatever name for the purposes of determining real controversies between the parties. On this submission, reliance was placed on the case of Bank of Baroda versus Iyalabani. The claimant simply sues the defendant, who he entered into contract with. The argument that Skipper Cell Nigeria Limited is not a juristic party is not true. The first defendant name and its common the first defendant is a juristic person. That is, the defendant name is, therefore the defendant is a proper party before this court. Counsel relied on the case of Chief of Army Staff versus Lawal on this submission. On the submission that claimants are not abiding by the terms of contract by refusing to resort to arbitration, it is submitted that paragraphs 5, 6, 7, and 8 of the claimant's counter affidavit and Exhibit BD notice of arbitration is a clear expression of good faith by the claimant to abide by every dictate of the agreement. Counsel further argued that the first defendant's staggered attitude is in unlawfully terminating the contract with the claimants without following due process upon the receipt of notice of arbitration is only an indication that it never meant well for the claimants and its employee. Counsel posited that the terms and the termination ended the life of the contractual relationship between the claimants and defendant. So any attempt to have proceeded to arbitration will be an exercise in futility, as it is common principle of law that a party who suffers injury from such an act should seek for damages. In support of this contention, reliance was placed on the case of Lagos State Government versus Toluwache. Counsel also submitted that this court has the inherent powers of allowing this suit to be heard on merit by eschewing all the technical grounds raised by the defendant. As according to counsel, gone are the days when technicalities were allowed in courtrooms to suffocate the case of justice. On this submission, counsel refers the court to the case of United Finance Limited versus Chartered Bank of Nigeria, where it was held for ONU JSC. Each party has a right to have his dispute determined upon the merit, and the court should do everything possible to favor the fair trial of the questions before them. Counsel also submitted that, assuming but not conceding that this court lacks jurisdiction to entertain this suit, the appropriate order to make is striking out of the suit for lack of quorum or transferring same to appropriate quorum for determination and not dismissing it. To support this contention, counsel made reference to the case of Okolo versus Union Bank of Nigeria PLC, where the court held that it has no jurisdiction to hear and determine the matter the proper order to make is that of striking out of the action, not dismissing same. See also Dean versus Attorney General of the Federation. In conclusion, counsel asked the court to discountenance and dismiss the entirety of the reliefs and technical objection raised by the defendants, by the learned counsel to the defendant, and here this suit on its merit. A reply on points of law, the learned six appearing for the defendants submitted that paragraphs 4 to 14 of the counter affidavit of the claimant filed on 23rd day of January 3 opens the provision of Section 115 of the Evidence Act, as they are conclusions and not facts within the knowledge of the deponent. To buttress the point being made, reference was made to the case of Nigeria LNG Limited versus Africa Development Insurance Company Limited. It is the submission of the learned seal that the duty to draw inference or make deductions from fact is that of court and not the deponent of an affidavit. It is submitted that prayers, objection, and legal argument are matters that may be phrased by counsel in court and not fit for the witness, either in oral testimony or in affidavit evidence, while conclusion should not be drawn by witness but left to the court to reach. On this point, counsel side, the learned cited and relied on the case of Bamei versus the state. The learned also asked the court to strike out the offending paragraphs of the counter affidavit after and submitted that after deletion of the offensive portions of the counter affidavit, it became bare and devoid of substance. In response to the submission of counsel for the claimant to the effect that any attempt to have proceeded to arbitration after termination will be an exercise in futility, the learned senior counsel submitted that the counsel for the claimant is the submission of counsel for the claimant is without foundation in law and demonstrate lack of appreciation of the import of the agreement entered into between the parties by the claimants. The learned continued his submission that generally arbitration clauses in a contract are generally regarded as autonomous agreements that may survive the termination of contract that contain it. This presumption is often referred to as separability or doctrine of separability. According to arbitration clause arbitration clause is separate contract whose validity and existence are independent from the substantive contract. To support this contention, the learned relied on the English case of Bana Bolcam, Shefborn versus Shefborn and Fabric versus Use Indian shipping. Reference was also made to paragraph 31 on page 56 of the contract on survival clause. It is submission of the learned that the import of the provision is unambiguous and in its effect on suing non-juristic person. It is submitted that counsel for the claimant insisted that the first defendant was rightly sued as Skipper Cell Nigeria Limited. Counsel further argued that Skipper Cell Nigeria Limited and Skipper Nigeria Limited are the same, without providing any proof to that effect. Counsel, while denying wrongdoing, stated that even if the court finds that there is any wrongdoing, the court is vested with inherent power to allow amendment to reflect whatever name for the purpose of determining real controversies between the parties. On this submission, counsel for the claimant relied on Bank of Baroda versus Iyalabani, Sufra. It is the submission of the learned that the position of counsel for the claimant is without any footing in law and has wrongly relied on Bank of Baroda because the facts and circumstances are entirely different from the present situation. It is also submitted that the claimants in paragraph 4, sub-paragraph 3 of his counter affidavit differs, though baselessly, that neither the first nor the second to fourth defendant ever protested against the name of Skipper Cell Nigeria Limited. As same is also concurrently captured on the front page of the contract of 14th day of September 2020. It is submitted that this is a total misconception of law as epitomized in paragraph 3.9, 3.10, and 3.11 of the claimant's written address in support of his affidavit. The complete answer to the unpardonable legal error afflicting the claimant's submissions can be found in the decision of the Supreme Court for Ariola JSC, now CJN, in the case of Geneva versus Africa Bank Nigeria PLC. The tried position of the law is that evidence of establishing legal personality of incorporated company is certificate of its incorporation. It is also the submission of the learned senior counsel that the claimant's prayer in paragraph 3.19 of the claimant written address for the transfer of this suit to an appropriate forum is misplaced and should be rejected without much ado by this honorable court, because this honorable court cannot wake up a dead horse. The suit, with respect, is dead on arrival. The recourse to which the claimants may have is not by way of litigation, and it is not the duty of this honorable court to make out a case for any of the parties. Counsel at the court to so hold and strike out the suit or otherwise dismiss them for constituting a gross abuse of the court process. The honorable court is urged in the circumstances, in the interest of justice, to grant the price contained in the defendant's application, as same will save the court time that could have been expended on dealing with other matters on the court's course list. In concluding his submission, counsel submitted that for the court to grant the price. In concluding his submission, counsel asked the court to grant the price as contained in the motion paper and hold that the terms of the agreement that they so firmly and voluntarily entered into. Court decision: I have considered the originating processes commencing this suit, the motion on notice subject of this ruling, its affidavit in support, the counter affidavit of the claimants filed in opposition to the defendant's application, the further and better affidavit of the counsel for the further and better affidavit of the defendant's applicants. I have equally perused the written addresses of counsel for both sides and listened attentively to the oral submissions canvassed by counsel in adumbration to the positions of their respective clients. From the content of the motion on notice filed on the 16th day of January 2023 by the defendant applicant, the objection of the defendant applicant to the competency of the claimant's action can be categorized into three. The first leg of the objection is challenging jurisdiction of the court to entertain the claimant's suit as it is presently constituted on the ground that the claimant's claim do not fall within the constitutional and statutory jurisdiction of the court, which borders on employment and industrial relation matters. The second leg of the objection is on misjoinder of parties, and the third leg of the objection is on legal personality of the first defendant. Let me state from the outset that the objection of the defendants on jurisdiction shall first and foremost be considered. The reason being that the jurisdiction of court is what circumscribes the legal power vested in court to determine rights and obligation and liability of parties before it who comes to seek for justice. Therefore, any determination conducted without requisite jurisdiction will amount to a nullity, and as no court will be allowed to adjudicate over a matter if it had no jurisdiction, and any such determination in the absence of jurisdiction will amount to nothing. That's why a court of law is vested with requisite power to investigate whether or not it has jurisdiction to entertain a matter brought before it by the parties for resolution. The law mandates the court to first and foremost accord prime attention to issue of jurisdiction. It has to be resolved before making any progress. See the case of Oku versus Ume, Britannia Nigeria Limited versus Safelat Pet Development Company Limited. See also Oni versus Cadbury Nigeria PLC. See also Diamond Bank Nigeria versus Ugochukwu. See also Ingere versus Okuriket. Due to the fundamental nature and importance of jurisdiction, it has variously been described by the court in their decisions. In Uti versus Onoebio, Far Bello CJN as of blessed memory has this to say concerning jurisdiction. Moreover, I quote, moreover, jurisdiction is blood that gives life to the survival of an action in a court of law, and without jurisdiction, the action will be like an animal that has been drained of its blood. It will cease to have life, and any attempt to resuscitate it without infusing blood into it would be an abortive exercise. Therefore, the jurisdiction of the court is derived from the constitution and statute establishing the court in question. Therefore, the question whether the court can exercise jurisdiction in an action would depend upon the endorsement of the claim on the writ of summons, that is complaint in this case, and the statement of claim, that is statement of facts in this case. Thus, where the endorsement on the writ of summons discloses a course of action, the court, unless precluded by other statutory provision, can exercise jurisdiction. Jurisdiction connotes the authority power of the court to determine a dispute submitted to it by contending parties in any procedure. See the case of Ajamole versus Yaduat. See also Mobile Producing Company Unlimited versus La Sepa. See Indayo versus Ogunaya. See Ibadobe versus Okoye. See also Society Big SA versus Chazin Limited. See also Garba versus Mohammed. See also Attorney General of Kwara State versus Ademo. See also Isa versus Anem. It is tried to know that a court of law is invested with jurisdiction to hear a matter if certain conditions are satisfied. That is to say, these conditions are: one, when it is properly constituted as regards the number and qualification of the members of the bench, and no member is disqualified for one reason or the other. B, that is number two, the subject matter of the case is within the jurisdiction and there is no future in the case which prevent the court from exercising its jurisdiction. Number three, the case comes before the court initiated by due process of law and upon fulfillment of any condition precedent to the exercise of the jurisdiction. These three conditions or ingredients of jurisdiction must coexist in order to best jurisdiction in a court. See the case of Madukolo versus Nkendili. See also Tukur versus Governor of Taraba State. See also Daro versus Union Bank of Nigeria. See also Okereke versus Eradua. See also Saraki versus Federal Republic of Nigeria. See Oni versus Cadbury Nigeria Limited. See Diamond Bank versus Ugochukwu. See Okpe versus Farm Milk PLC. See Bello versus Damisa. See also OC versus Accord Party. Therefore, in determining existence or presence or non-existence or absence of jurisdiction, the court is enjoined to consider the constitutional and provision and statutory provision vesting it with jurisdiction vis-a-vis the statement of claim, which is the measure barometer a court will use to measure the presence or absence of jurisdiction. See the case of Ikene versus AJ Dore, ADS Limited versus ATH, Oni versus Cadbury Limited, Sufra Ladoja versus Ajimobi, Eradua versus Yadao, Akpombo Okadibo versus Chidi, Isa versus ANEC, Agi versus PDP, and host of other cases cited therein. In the case at hand, the constitutional provision investing this court with jurisdiction is section 254C of the 1999 Constitution as amended, and the statutory aspect of it can be found in section 7 of the National Industrial Code Act 2006. Indeed, this court is imbued with jurisdiction to hear and determine or adjudicate on cases involving employment, labor, and industrial relation matters. For the proper appreciation, the provisions of section 254 of the Constitution as amended conferring this court with necessary jurisdiction to enable it effectively perform the duties assigned to it by the Constitution is hereby reproduced verbatim for purposes of clarity and emphasis. The relevant provision of the Constitution that donates the jurisdiction of the court read as follows. I have reproduced the entire section, so I will jump reading it. I will jump reading the content of the section. It is clear from the provision that the exclusivity of the jurisdiction of this court was given judicial affirmation in the Court of Appeal case, where it was held that section 254C of the 1990 Constitution as amended by third alteration act expand the jurisdiction of the National Industrial Court by investing it with exclusive jurisdiction over all labor and employment matters. In the instant case, by virtue of the new provision, the trial court's jurisdiction completely migrated to the National Industrial Court, which forthwith have the exclusive jurisdiction in all matters enumerated thereunder. Juxtaposing the above constitutional provisions, the case law with the general form of complaint and the statement of facts commencing this case, this suit, which are the processes which the claimant use in commencing this action, it is apparent after having a holistic view of the originating processes in the present action. The present action as it is presently constituted is not an employment matter, as there are no facts deposed to in the statement of facts filed by the claimant to establish cause of action on contract of employment or claim for entitlement arising from contract of employment between the parties. Rather, what is clear to me is that the fact that by the reliefs being sought in the statement of claim and as endorsed on the complaint and the front-loaded documents attached to the originating processes commencing this suit, the claimant's action is predicated on termination of contract for construction work, irrespective of contract for offense cycle gas-fired power plant near Tinapa Business Complex, Adiabo Town, Calabar, Cross River State. The dispute between the claimants and the defendant is for declaration regarding failure to supply construction site, refusal to pay claimants the contract sum, payment of special damages as agreed and contained in the contract agreement, payment of costs incurred for maintaining personnel and equipment on site for 330 days, which amounts to 11 months. General damages as compensation for breach of contract and cost of litigation. It is clear from the above reliefs of the claimant which have been reproduced in the earlier part of this judgment, and upon holistic consideration of the entire processes in the case file, that there is no breach of any contract of employment that existed between the claimants and the defendants, which they have brought before this honorable court for determination. The relationship between the claimants and the defendant, as shown by the originating process commencing this suit, establishes a contract for service and not contract of service. Therefore, this court, which has jurisdiction only to hear and determine labor matters, does not have the bias to entertain the claim of the claimants as it is encapsulated in the general form of complaint and statement of facts commencing this suit. The subject matter of this suit, being that of contract for service, does not qualify to belong to the category of contract of service, which this court is established by law and the Constitution to adjudicate upon. See the case of Shena Security Limited versus Afro Park, where the Supreme Court provided guidance on how to discern existence of contract of employment. The fact of this case did not disclose any employment relationship to which there is an agreement on payment of salary or wages to the parties before the court. In view of the foregoing, I have no choice than to come to the conclusion that this court lacked jurisdiction to entertain the claimant's case as it is presently constituted, and there is no dispute, as there is no dispute on employment relationship between the parties and between the claimants and the defendant, which have been brought before the court for adjudication. Having come to the conclusion that this court has no jurisdiction to entertain this suit, the consideration of the other legs of the objection, that is misjoinder and issue of legal personality of first defendant have become odious, as it is not as the objection of misjoinder is not an issue of jurisdiction of the court. And having found that the court has no jurisdiction, there is no basis for delving into the issue of misjoinder and issue of legal personality of the first defendant. The counsel for the claimant has insisted that the appropriate order to make is that of striking out of the case and not dismissal as being canvassed by the learned sick. I quite agree with the counsel for the claimant that where a court has come to a decision or to a conclusion that it has no jurisdiction to entertain a matter, the appropriate order to make is that of striking out of the suit and not dismissal of the said suit. Having come to the conclusion that this court lacks the requisite jurisdiction to entertain this matter, I hereby strike out the matter for being incompetently before the court. Ruling is entered accordingly, and I make no order as to cost.
As the court pleases. My lord, I want to thank your lordship for this well-reasoned ruling.
Thank you.
Even though we will have asked for cost, but with respect to your lordship,
I have already foreclosed you on doing that.
I quite understand that, sir, and I would respect your lordship's decision. We are most grateful, sir. We are most grateful, sir. Thank you, sir.
Yes, thank you, Lannis. You can discontinue with the call. You can discontinue. Yes, Lannis.
I'm most grateful, sir. We'll do that.
Okay. Yes.
Thank you, sir.
Police case.